Jerry Nadler.
Thank you, Mr. Chairman. Let me start with a couple of observations. First, I think what Professor or Mr. Presser and Professor Rapkin said is totally wrong. Impeachment has nothing to do with personal benefit, has nothing to do with motives or good faith. That's not the issue of impeachment. The issue of impeachment is, did the president commit an abuse of power that would tend to destroy liberty or flout the structure and function of government by, in particular, by reducing or traducing the separation of powers, which is the basic protection of our liberty. And that's what we look to, and that's what the report of the House Judiciary Committee in 1974 said, and that's what we look to at any time. Secondly, let me just comment on Mr. Rapkin. If the president lied to Congress, and I think there's good evidence that he did, if the president lied to Congress in order to motivate Congress to go into war, he may have had a motive thinking that it was in the national security interest of the United States to go to war for some other reason which would not be persuasive to Congress, and therefore he lied to Congress. That would be impeachable. Maybe. Because it's not up to him to decide what phony excuse would get Congress to do what he believed in good faith was the right thing to do, because that's up to Congress to exercise its powers. Thirdly, we are in a very, very dangerous situation now in terms of our liberty. We have a president and an administration that claims the power. I don't believe the Supreme Court is going to let them get away with it, but that holds by one vote, to point their finger at any person in this room and say, you're an enemy combatant because I say so. And because I say so, we're going to throw you in jail forever with no hearing, no due process, no anything until the war on terror is over 6 or 7 generations from now when some president declares it over. No executive in an English-speaking country since Magna Carta has claimed such a power. And so far they're getting away with it. It is the foundation for a future tyranny. And finally, equally, the way they have tied us in knots, the administration, in effect, says we can, they don't put it in these terms, but they've asserted the power to kidnap someone off the streets, send him to another country to be tortured, or torture them himself, or do any other illegal thing. And when you say, well, that's a crime, prosecute it, they don't prosecute. And when you bring a lawsuit, they say, wait, you can't bring a lawsuit, case must be dismissed because it violates the state secret doctrine. So there's no way, there's no remedy to any misconduct by the executive branch of government because they won't prosecute at law. They claim executive privilege, they won't tell Congress about it. And anybody brings a lawsuit, they claim state secrets, so you can't even get into court. So there's no remedy to any abuse of power or any action whatsoever by the executive. We've got to figure out a way around all this. Now, I have been quoted in the past as saying that I did not think impeachment was a practical remedy, though God knows it's deserving. My first question to Mr. Fein, because I heard in your testimony, I believe, you said that in an impeachment inquiry, executive privilege does not apply. I think
that's correct, and Liz was right there.
All right. I think you said executive privilege does not apply. Now, my understanding, and correct me if I'm wrong, please, is that Congress has taken that position, but the executive branch has never agreed to it. And if, in fact, the administration has gone so far beyond the pale, beyond any previous interpretation of executive privilege, as to say to Karl Rove and other people, don't show up, just ignore subpoenas, and to the U.S. Attorney, never mind the mandatory language of the statute, don't enforce the contempt citation. How would we, were there to be an impeachment inquiry, effectuate executive privilege against the same sort of conduct?
Simple. You do what was done in the Nixon inquiry. You vote an article of impeachment saying it's an impeachable offense to refuse to comply with a request for information.
So in other words, you couldn't, what you're saying is they could have the same far-reaching claim of executive privilege in an impeachment inquiry as they could in any other committee hearing, but the remedy is to vote in impeachment.
And then they're out of office, yes, sir.
In other words, holding the impeachment inquiry doesn't get around the executive privilege problem, but voting the impeachment and exactly removing him from office is the only thing that would.
That worked with Nixon.
And that would work with a lot of other problems. Let me ask you a different question. All right, let me ask, I think it should be either you or Professor Schwarz. You expressed hesitation at the practicality of impeachment. Now, The first President Bush pardoned senior members of his cabinet who were involved in the Iran-Contra scandal. It foreclosed any possibility of pursuing those individuals for their activities, no matter how lawless they may have turned out to have been. It also foreclosed any option of coercing their testimony as to the possible culpability of the president in that. Now we are beginning to see suggestions that this President Bush should pardon people involved in illegal torture, illegal wiretapping, outing a CIA agent, and anything else. Does Congress need to explore changes to the pardon clause of the Constitution to prevent it from being abused by a president who may wish to prevent scrutiny of illegal acts of his own administration or of himself personally?
Yeah, you could not affect the pardon power, which is one of the very.
I said, should we look at a constitutional amendment?
Exclusively in the hands of the president, unless you amended the Constitution.
Well, my question is, should we look at amending the Constitution in that respect?
I think if you have a justification for it being abused, that's fair to look at. That's definitely fair to look at.
Mr. Fein.
Congressman, I think there's a statutory procedure that would deter abuses of the pardon power. That is, if you, and I think this would be constitutional, if the president was to use the pardon power to pardon people of his administration for alleged crimes that involved abuses, it would have to be 6 months, 8 months before his term ends, so he would clearly suffer a political penalty.
Why couldn't it be the day before his term ends?
Well, the approach would be the statute would try to regulate, not
you're saying that
power, to say that you make him exercise the power sufficiently before his term ends, so he's got to pay a political price, so he can't go like Mark Rich out the door and pardon someone and then escape any political retribution. If you forced him to make that decision 6, 7, 8 months before he left, then he needs to confront the
Do you think that such
a
well, let me ask Mr. Schwarz, and Mr. Fein, would a bill, not a constitutional amendment, a bill to say that the president couldn't pardon any member of his own administration after 6 months or whatever, before the end of his administration, would that be constitutional? Or it's a limitation on the pardon power?
It would be a litigable matter, I would think.
Congressman, the authority comes from Article 1, Section 8, Clause 18. It's the necessary and proper clause, and what it says is that Congress has authority to enact all laws necessary and proper for the execution of any power under the United States or any department or officer thereof. That is, it applies to the execution of executive Well, I think that goes too far. Of course, all constitutional law becomes matters of degree when we get cases, but there you're eliminating the president's discretion to exercise pardon at all for a particular category he made, and the pardon power is broad enough in terms of the scope to protect people against retaliation from somebody that the president thinks has been unjustly hounded. I doubt that would survive, but that's different than just a time limitation.